So our first presenter is Judge Mary Huffman from the Court of Common Pleas in Dayton, Ohio. Judge Huffman is a trial judge, day-to-day does trial judge work like several of us do in the room today. But she's also lectured and written widely on the subject of sex offenders. And I've looked at her PowerPoint presentation. It's a very interesting presentation that talks about sex offenders generally and some of the issues surrounding sex offender registration. So please welcome Judge Huffman.
Good morning, everyone. This is an intimidating group. I like to walk around when I present, and I don't think that's going to be possible today, so I'm going to be sort of stuck here behind the podium, so I apologize if I get away from a microphone. I'm going to be talking today about the myth of sex offenders and then the judicial perspective relating to sex offenders. But I want to tell you first about how I first got interested in this topic, because as a judge, in a state where we're elected, it's not a very popular topic to advocate on. About 8 years ago, I was taking a class at the National Judicial College on criminology, and that the National Judicial College is on the campus of the University of Nevada. And the professor in this course asked all of the judges in the class to bring with them an example of a case that troubled them, where they had to do something that really bothered them. And I had just so happened to have had a case involving an 18-year-old boy who had had sex with a 14-year-old friend of his sister's. It was consensual, but in Ohio it's a felony. He was an adult, she was 4 years younger than he was, and the crime in Ohio is unlawful sexual conduct with a minor. Does not require any force, does not require any compulsion. It's a consensual act with someone who is deemed to be incapable of consenting. And in Ohio, that young man is required to register as a sex offender for 15 years. And it troubled me that someone, I had a bailiff at the time who said, he's not a sex offender, he's immature, and he doesn't understand appropriate dating practices. And that probably summed up the situation. But he is required to register for 15 years. And so that course started me on this interest in sex offenders. And unfortunately, I will tell you that that young man, who I sentenced to probation, it was not a case in Ohio that prison was required. He is now in prison for failing to register. And Ohio has a mandatory sentence on your second offense for failure to register. And unfortunately, I drew that case also. And it gives me goosebumps to think about it, that this young man is sitting in prison for 3 years because he doesn't have the resources to assist him in understanding what day each year he has to register. And so that is the reason I'm very passionate about this topic and the need for evidence-based practices in sex offender registration laws. So let's talk about how we got here. We now know a lot more than we did 25 years ago when the push for sex offender registration laws started in the United States, or the renewed push for sex offender registration laws started. People like Eric Janis, who you're going to hear from in a little bit, are the experts in sex offender registration, sex offenders, what sex offenders are. Much of what I'm going to talk about at the beginning or throughout the presentation comes from people like Eric and other researchers. But we now have a much better understanding of sex offenders than we did when we enacted the laws that we're dealing with today and that you are grappling with. What is a sex offender? In terms of the definition of sex offender that I'm going to employ, it involves anyone who commits a violent offense on a stranger or a family member. It's a very broad spectrum, obviously. Anyone who engages in inappropriate contact with a family member, consensual sexual contact with certain persons. So in some states, for instance in Ohio, if you have consensual sex with someone who is deemed to be incapable of consenting, someone who's intoxicated, someone who is disabled, and someone of a particular age, it is a criminal sexual offense. And then any offense, whether it's in the state system or the federal system, that involves viewing images of children that are, I'm going to very broadly stated, are inappropriate. These are very broad definitions of sex offenders, but they also do not take into account the individual characteristics of sex offenders. You'll hear more later today from the experts on these issues about sexual offending. While all sexual offending is socially deviant, not all sexual offending is sexually deviant. And so, for instance, again, the 18-year-old boy having sex with a 14-year-old girl, he's very immature. She quite frankly felt that she was very mature. That's not sexually deviant, but it's socially deviant. And who among those persons should we be penalizing by requiring them to register as sex offenders? So let's talk about how did we get here. And one of the theories associated with sex offender laws is the moral panic theory. And how many of you have ever heard of moral panic theory? So, okay, great, some of you have. And it's a phenomenon that when I first learned about this, it was one of those moments where you hit your head up beside the head and say, wow, so many of our laws are based upon a moral panic. So what is a moral panic? First of all, it is a cyclical process that generates to such hyperactivity that we become so in tune to this problem that we accept it as the truth. Think back about what we refer to often as the AIDS epidemic. If you remember back in the mid-1980s when we first learned about the HIV virus, there was panic. People were afraid. My youngest son had a blood transfusion shortly after he was born in 1986, and the doctor told me he's going to have a transfusion. And I remember thinking, oh my gosh, where's the blood going to come from? It was an unrealistic fear. But the fear had been generated from a moral panic. So let's talk about moral panic, and then we'll talk about how we got here with sex offender registration and a moral panic. One thing that's very important to understand about a moral panic is that there is no evidence to support the panic. So what happens? We have a concern that arises from typically some startling event. A child is kidnapped. A child is murdered by someone that we believe is a sex offender. And then the media catches this. And then the media starts generating fear. And then the public becomes hostile to the individual or the group of individuals around which this startling event occurs. The reaction to the fear is not proportionate to the actual threat. And we'll see that with sex offenders in the statistics that we'll talk about in a few moments. But with a moral panic, it's a process that continues to regenerate itself. The event occurs, the media picks it up, the public panics, the media picks it up again, and we just have this sort of hyperbolic, exaggerated understanding of a fear that is irrational. The fear I had about my son getting a blood transfusion. It was not rational, but the fear was based upon everything that had occurred in the media. The media is one of the most important agents in the moral panic theory, because as members of the public, and I suggest that most of you likely do not because you're sitting in this room, and you, I assume, have a very enlightened concern about this topic, but members of the public likely don't have the same concern that you do. And they will listen to the media and become fearful about sex offenders, and unfortunately the moral panic often drives legislation. In a little bit, we're going to talk about the Adam Walsh Act, and there are a number of parts of the Adam Walsh Act. 17 portions of the Adam Walsh Act are named after children or women who were either sexually assaulted, murdered, but the named portions of the act are because of the fear. People were we have got to do something in the name of my friend, my family member who was killed, and so we have to do something more. Again, it's this moral panic that often drives legislation. And if you look at the photographs on the screen, this is what the public believes a sex offender is. A guy in the playground who's going to offer your child candy. Somebody's going to abduct you from a public place. Some creepy guy. I got these pictures off the internet. I'm sorry to whoever this guy is. But doesn't he look like the creepy? I even Googled it. Creepy guy in the woods. That's our common perception of sex offenders. Is that it's some stranger lurking in the woods. And the moral panic associated with sex offenders has driven the public perception that we have up on the screen. These common misperceptions that are not factually based. Since the mid-1990s, there's been quite a bit of research on public perceptions, legislative perceptions, perceptions of professionals, whether it's therapists, probation officers, relating to sex offenders. How do they perceive them? Very interestingly, the research demonstrates that probation officers have the same perception of sex offenders as members of the public. And I'm going to use a term that may sound rude, but uneducated members of the public. Members of the public who know nothing about the research related to sex offenders. So what are those perceptions? Well, first of all, unfortunately, legislators, because there is some research on legislative attitudes towards sex offenders, they have the same uneducated attitudes that members of the public have about sex offenders. The research demonstrates that the public, whether it's the legislatures, probation officers, et cetera, they accept the media-driven narrative related to sex offenders. What does the media tell us about sex offenders? And that is what is generally accepted. The public believes that sex offenders will inevitably reoffend. We're going to look at some statistics on that in a few moments. They support harsh restrictions. And what do we mean by restrictions? Either lock them up, isolate them, not in my neighborhood, somewhere else. The concern is not on either rehabilitation, reintegration, but instead it is on incapacitation. Get them out of the public. There is little value found by members of the legislature or the public in treatment of sex offenders. There is a perception that, as I said, inevitably sex offenders will reoffend, and they will reoffend against strangers. And finally, and perhaps most disturbingly, the general perception is that sex offender laws currently are simply not harsh enough. So let's look at the history of registration laws. We have a long history in this country of requiring registration of individuals, whether it's for sex offenses or other offenses. And I have to tell you that in Ohio, our legislature has gone crazy for registries. And the Ohio Judicial Conference and other organizations have told our legislature registries mean nothing. They do nothing to assist. Well, we now have an arson registry. We have a cruelty to animal registry. We have a violent offender registry. I was at a meeting a few weeks ago of our judicial conference, and we told some legislators, pretty soon we're all going to be on a registry because they have just gone crazy with registries. But let's look at the history of registries. They started in the 1930s in California, where California the legislature perceived that they had a problem with what they called gangsters. And they needed to be able to identify gangsters, and the registries were for law enforcement purposes only, so that the law enforcement officials could know who had some affiliated gang membership, much different than the gang membership that we would perceive or we would understand today. In 1944, California said, well, gangs aren't such a problem here anymore, but sex offenders are. And California required, just a few years later, that all sex offenders, anyone who had committed an offense of a sexual nature, be on a registry for life. Well, then, during that same time frame, there was, and you're going to be hearing from some psychologists and others today who can give you a much better description of these laws than I certainly could. But there was this movement in the medical and I guess I'd say the psychological community that there was some discrete diagnosis of someone who will commit a sex offender, that they had certain traits, and that we need to lock those people up in either a medical or a mental health facility. We didn't call them those things back then. They were much more pejorative terms that were used for the facilities that these individuals would be placed in. But in the 1960s and 1970s, a lot of that legislation that required, they were often known as sexual psychopath laws, that there was no such thing as a sexual psychopath in the very broad definition that was used in the community at the time. And the medical and psychological professionals recognized that there is no one character trait, there is no one diagnosis that we can lump all of these individuals into. And so states began repealing their laws that required people convicted of a sexual offense to be effectively locked up in some mental health facility after they had completed any criminal sentence. By 1986, there were only 5 states in the United States that required some type of sex offender registration. It was typically only accessible by law enforcement. It certainly was not accessible by the public. That all changed in the 1990s. In, I believe it was 1989, a young boy from Minnesota named Jacob Wetterling was out on, I believe it was a Sunday night, with his brother and a friend. He was a young boy. He was 11, 12, somewhere in that neighborhood. They had gone to get a movie, and as they're riding their bikes back about 9 o'clock from the video store, they encountered a man who had a gun. And he had them get down on the ground, and then he looked at their faces. And he had 2 of the boys, the brother and the friend, he said, run into the woods. And Jacob Wetterling was never seen again. And about 5 years later, we had our first federal regulation of sex offender registration. Now, I want to say how the moral panic was involved in the Jacob Wetterling Act. The perpetrator of the offense against Jacob Wetterling was not known until 2016. His body was not found until 2016. But in 1994 and in 1989, when this occurred, there was an immediate knee-jerk reaction. This must have been a sex offender. This must have been sexually motivated. Do we know that now? Yes. Was it known in 1989 or in 1994? Absolutely not. But that moral panic began generating with this event. And so the Jacob Wetterling Act, again, first federal legislation involving sex offender registration, required that all sex offenders be tracked for law enforcement purposes only. So it was our first effort at a registry. Also, I'm sure you all understand that while this was a federal law that imposed sex offender registration requirements, states must enact their own sex offender registration legislation to be consistent with the federal acts, because the federal government has absolutely no jurisdiction or authority over sex offender registration. There's nothing in the U.S. Constitution that reserves that issue to the federal government. We all know how this happens. It happens to all of us, I'm sure, in your day jobs. It's the power of the purse. The federal government, as we'll see with the Adam Walsh Act, there's money tied to whether you comply with this federal legislation. Now, just 2 years later, in 1996, the federal legislature, the U.S. Congress, passed Megan's Law. And the victim in Megan's Law, that was a sex offense, and it was known immediately that she was the victim of a 2-time convicted sex offender. The little girl, her name was Megan Kanka. She lived in New Jersey, and there was a man living across the street, and I'm sorry, I've never been able to pronounce his last name. His first name was Jesse, and he invited her over to see his puppy. And the classic media-driven example of a sex offender. He invites her over to see his puppy. He sexually assaults her, murders her. He admits to it within days. The perpetrator was discovered very quickly. Very quickly, within a very short period of time, the New Jersey legislature passed the first Megan's Law that then became the federal legislation, Megan's Law, which permitted states to make registration information publicly accessible. And in Ohio, we quickly passed Megan's Law, and from the time I took the bench in 2002 until 2008, we were operating under Megan's Law. And again, federal legislation imposed on the states through the power of the purse. There was obviously a clear sexual motivation in the case of Megan Kanka. In the case of Jacob Wetterling, we didn't know that there was a sexual motivation until 20 years later. So let's talk about the classification systems prior to the Adam Walsh Act. States had a variety of different systems of classifying offenders. There was the offense-based system that we know under the Adam Walsh Act. Whatever your offense was, let's put it on a grid, and that offense equals this registration requirement. Other states required registration based on the number of convictions. One conviction, you might be classified in a particular manner, subject to certain restrictions. Another, 2 offenses, more restrictive, et cetera. And then there were some cases, and Ohio was one of them, where we had an individual risk-based system. And so in our system, it was very much like other states that employed the same risk-based system. We had sexually oriented offenders. Those were persons who were considered to be lower risk. We had sexual predators who were considered to be higher risk. And then we had habitual sexual offenders who were anyone with a prior sexual offense conviction. And what did we use to determine the categories? Well, we used risk assessment tools, whether it was the Static 99 or other available tools. We used psychological evaluations or evaluations by professionals, not my uneducated knee-jerk reaction to that person's behavior. We would get an entire criminal history, a social history. We would have an actual hearing, take testimony on what the appropriate level of supervision would be required for that offender. That all changed with the Adam Walsh Act. And I use this picture because I think it's indicative of just what happened when the Adam Walsh Act was passed. I am not diminishing the pain of the Walsh family, the horror that they went through. But the act which bears their son's name is terrible. It has consequences that were not considered. I'm sure that most of you haven't sat up at night and read and I don't advocate it. I have done it, and it's rather disturbing. I'm sure you haven't read the congressional hearing testimony and the Senate hearing testimony when the Adam Walsh Act was passed. Why is it painful? Because there's no evidence included in the testimony. Not one professional testified about the evidence that we know relating to sex offenders. The only testimony was from family members of victims and from senators and congressmen who stood up and said, this is awful, this is horrible, we have to get those horrible people off the street. And I want to read to you a quote that should demonstrate to you that the moral panic was part of the generation of the Adam Walsh Act. This is from Senator Orrin Hatch. I could have picked 30 other senators or congressmen who made similar statements. This just happens to be the shortest one. I want to thank the American Press Corps for the attention it has given to this issue. News outlets have diligently raised the American public's awareness of the grave threat posed by today's sexual predators. What evidence was contained in that statement? None. And just like the other senators and congressmen who spoke in favor of this legislation, there was no evidence included in the debate. There was no debate, folks. It was a disturbing way to pass legislation, but it was legislation based upon a moral panic. And as I said, 17 subparts of the legislation are named after persons, 14 of whom were 16 years of age or younger. As I had mentioned at the outset, the moral panic often results in legislative change, and the Adam Walsh Act is evidence of that change. The Adam Walsh Act provides that if states do not comply with the Adam Walsh Act, they will risk losing 10% of their annual burn justice assistance grant funds. There are a number of research studies that I'm happy to refer you to that discuss the amount of money states would lose in their burn justice assistance grants by failing to enact the Adam Walsh Act. Ohio was, I thought, the first. I learned this morning maybe that Florida was the first to pass the Adam Walsh Act at the state level. And we were at risk of losing $600,000 in burn justice assistance grant money. That's very important money that is used for a lot of very significant programs, except it cost us $12 million in first-year cost. That's just first-year cost of implementing the Adam Walsh Act. We were going to lose $600,000. It cost $12 million in state dollars. That does not include the cost to the individual defendant, the registered sex offender, and the collateral consequences associated with their sex offender registration. So how different is the Adam Walsh Act from the prior risk-based systems? The Adam Walsh Act is absolutely an offense-based system. There is absolutely no consideration given to the offender's individual characteristics. There is no judicial discretion. And so where I used to have a hearing and we'd bring in experts and we'd have a risk assessment and we'd have a full criminal history and a full social history, the defendant would offer witnesses, the state would offer witnesses. Now it takes me 2 minutes to read a form. And that form is based on the defendant's offense. It's not in any manner based on their individual risk. So Tier 1, as you probably know, those of you who have any involvement, Tier 1 is a catch-all category. Tier 1 is actually the lowest tier. Less serious offenses, registration is once a year for a period of 15 years. Tier 2 involves things like child prostitution, pornography offenses, sexual contact with minors. Sexual contact and sexual conduct are 2 entirely different. I know it sounds very similar, but legally very different. Contact would be touching. Conduct is what we would consider to be penetration. Those individuals on Tier 2 are required to register every 180 days for 25 years. Tier 3, the more serious offenses, they're all serious. When I say more serious, I mean threats, physical harm, penetration. In Ohio, we have, and it's actually in the Adam Walsh Act, non-parental kidnapping of a minor is assumed to have a sexual motivation, and therefore Tier 3 lifetime registration every 90 days. As you can see, it's a scale that has ever-increasing responsibilities to register based upon what are deemed to be categories of offenses. States come into compliance with the Adam Walsh Act by being approved by the worst acronym ever, the SMART Office. And the SMART Office, I always forget what it stands for, Sex Offender Management, something else. It's a federal agency, a federal department of the, let's say it differently, a division of the Department of Justice. And the SMART Office determines whether states are in compliance with the Adam Walsh Act and therefore continue to get their burn justice assistance funds. I will also say that all of the Indian nations are also required under the legislation to be in compliance, and many of them are. Most states are in compliance with the Adam Walsh Act. If you look at the SMART Office website, you can quickly, it's available to the public, quickly learn what states are in compliance. Now, the Adam Walsh Act not only requires registration, but it permits full public access to the information on the registry. So what does a sex offender look like? These pictures, again, these people are on the sex offender registry, and they all live within 2 miles of my house. So I figured I'll just use where I live. Do any of these 2 people look? We have young girls, older men, large people, small people. There is no one characteristic of a sex offender. They look like you and me. They have lives like you and me. But unfortunately, the law puts them in these categories and says you all look alike. So let's look at, this is just a national snapshot of sex offenders. And before I talk about this, I do want to say that these statistics, I have taken them from research. And the research, you may find, Eric and I were communicating a couple of days ago, some studies will use a figure of, for instance, 84%, another one 95%, but these are all statistics from verified research. The average age of a person on the registry, not at the time of offense, but on the registry, is 44.3 years. 66% are Caucasian, 98% are male, 80% are adult, and I think there's an entirely separate conversation over juvenile sex offender registration. That is not my area of interest, and by that I mean my area where I've done any research, but that is an entirely different conversation. Approximately 90% of those on the registry have a minor victim. The victim was a minor. And interestingly, for purposes of community safety and the attitude that was evidenced in the limited debate on the Adam Walsh Act, where we were going to make the public safe from these predators that are out there lurking in the bushes, 96% of the people who commit sex offense, I shouldn't say it that way, 96% of the people who are convicted of a sex offense were not on the registry at the time of the offense. And so this stranger danger attitude that we have, we've got to, go after people that are lurking in the woods, and people are inevitably going to re-offend, does not bear out in that statistic. So let's look at the victim-offender relationship. Again, you will see different studies that have slightly different statistics, but we've got a category of all the victims, adult victims, child victims. 26% of the victims are victimized by a family member. 11% of the adults are victimized by a family member. 34% of the children are victimized by a family member. I don't want to go through all these statistics, but add up the statistics on child victims. 93% of offenses committed against children that we know about, are committed by a family member or a known individual. Neighbor, daycare provider, family friend, whomever. Only 7% are committed by a stranger. And the statistics with regard to adults are, while they're different, they bear a similarity. How often do we let our children go out into the community by themselves? Not as often as an adult. We are out in the community and have an opportunity for a stranger to offend against us. And so only 27% of adult victims were victimized by a stranger. I'm going to go really quickly through this because I think this is going to be the topic later today of someone else's discussion. The statistics that we have on sex offending, we know are not good. Now, they are good based on what is reported. But we also know that more than half of all sex offenses go unreported. And if you look at these statistics I have here for you, 80% of college students or college-age individuals don't report. The elderly don't report 72% of the offenses. And look at the military. Male members of the military underreport 90% of the time. 90% of the time. There's obviously a dynamic related to their military service, their gender, that causes them to believe that reporting is not a good idea. Why do people report? We're going to look at two things. Why do people report and why don't they report? Again, this is based on a number of research studies that asked people who were victims, why did you report? Why didn't you report? Well, obviously they want to protect themselves. Maybe it's a mother who's going to report an offense against a child. They want to protect not only themselves or a family member. They want to stop the abuse or prevent it from happening in the future. Many of us, and I suspect many in this room, have a duty to report. How many of you are mandatory reporters? A lot of you, all right? So I'm not certain about your mandatory reporting laws in Connecticut, but in Ohio, as a lawyer, I'm a mandatory reporter. And mandatory reporting is actually broadening. There is some federal legislation a couple of years ago that makes all youth sports administrators and coaches mandatory reporters. Because if any of you are involved in the criminal justice system, you know that we have a huge problem with sexual offending by coaches. We now have federal legislation that requires mandatory reporting by anyone involved in youth sports. And then obviously a reason to report is we want justice. We want something to happen to that offender. But there's a lot of reasons people don't report. And they, in some respects, mirror the reasons people do report. Fearing retaliation. I don't want, are any of you victim advocates? Anybody here a victim advocate? I'm sure you all have experienced victims who tell you, I don't want to go to court because he's threatening me, my family is cutting me off, they believe him and not me. There are a lot of reasons that victims either choose not to report or choose not to follow through with the prosecution because the consequences to them are setting aside the trauma that we know is obviously unbelievable and unbearable. The consequences to them in their family relationships, the public knowing, the embarrassment of having to come into court in a public setting and testify, the consequences are significant. Many people believe the police either will not believe them or will not help. They'll believe the older person, they'll believe dad, they won't believe me. Again, mirroring the reasons people report. Sometimes people are afraid their family member, their loved one will get in trouble. We'll just stop. I've heard that many times. We'll just stop this in the family. We'll take care of it. We don't need the justice system to take care of it for us. And then There's the feelings of shame, guilt. It was my fault. I should have stopped it. There are a lot of reasons people don't want to report. I'm going to go quickly through these also because, again, you're going to have some experts later who are going to talk about, who are much more equipped than I am to talk about factors that contribute to sexual offending. But I will tell you, as a judge, I have experienced individuals who either are on trial or convicted of a sex offense who clearly demonstrate these factors. An asocial lifestyle, low self-control, low or poor coping skills, opportunity. So I had a case recently that involved a coach, and he had great opportunity for his offense because he drove this 14-year-old girl home from practice a couple times a week, and her parents weren't terribly involved in her social or her school life. And so the coach said, I'll pick her up, I'll take her to practice, I'll pick her up, I'll take her to the game. What kind of opportunity? He had a great opportunity because A, she had parents who were very uninvolved in her life, in what was going on with her, and B, he had a physical opportunity because she wasn't going to call her parents and say, guess what the coach is doing? And he had the physical opportunity. And then he also used it as an opportunity, as a very, you all, I'm sure if you've had any cases or circumstances dealing with coaches or grooming, he isolated her from her parents. Your parents don't care about you like I do. Look, your parents don't come to your game. I'm the one that cheers for you at your game. And so, very opportunistic offense. What about online offenders? And so, my experience with online offenders is, and by that I mean, we have a crime in Ohio called importuning, and importuning is soliciting a minor for sexual activity on the internet. But online offenders, whether it's child pornography, importuning, Caucasian and male, those are the primary persons. The victims are primarily Caucasian, that is, they're targeting Caucasians. Again, now you're going to hear from some folks this afternoon who have a lot more expertise in this area than I certainly could. But those individuals have more sexually deviant interests and a much lower rate of prior criminal involvement. And speaking anecdotally, my experience with online offenders is that they are professionals. Again, this is purely anecdotal. Professionals, employed, this is what they do in their off hours. Again, that's purely anecdotal. But let's look at the typical criminal, and by typical I mean non-sexual offender. Non-sexual offenders typically engage in a wide variety of criminal offenses, and that is, today they might steal your car, tomorrow they might break into your house, the next day they might get into a bar fight. So there is no pattern of offending typically in most criminal offenders. They rarely specialize, although I will tell you I have a number of offenders who specialize in theft, and they do it badly because I see them often. Yeah, if they were good at it, I guess they'd find another occupation. The risk factors for general criminal behavior: youth, unstable employment. So if you think about that, if you are older, more mature, you have a family, you have employment, you are less likely to commit a criminal offense. We see professionals all the time, but you are less likely to commit an offense. And then pro-criminal or asocial attitudes contribute to criminal offending. I'll give you an example. A young guy who likes to steal cars, and I told him once, you could really solve this. Get a bus pass, okay? Get a bus pass, and you won't need to steal cars. Because why did I say that? Because he said to me, I had to get somewhere. He had this asocial or pro-criminal attitude that I have a need. How do I meet my need? I meet it any way I can. I just go and steal your car. And so he had a lifestyle or attitudes that reflected this general criminal behavior. And we've talked about these as factors relating to criminal conduct. They're the same factors that relate to recidivism. Youth, being unmarried, unfortunately minority status often is a recidivism factor. Prior criminal involvement, well, if it's recidivism, you had to have prior criminal involvement. And then some either antisocial personality or psychopathy is a general predictive factor of recidivism. But let's compare some recidivism rates. You know, the general public, as I said, they think all sex offenders inevitably will reoffend. Let's look at some statistics relating to recidivism. The general recidivism rate among all criminal offenders, roughly 62 to 67% will commit a new offense within 3 years of release from prison. That's all offenders. And let's look, we've really gone over this a bit, recidivism among sex offenders. Age, marital status, prior sexual offenses. The two in yellow are the ones that are the more highly predictive. Again, according to the literature, you'll hear much more from experts regarding this later. Antisocial orientation or lifestyle instability and sexual deviancy are the stronger predictive factors for reoffense, not reflected anywhere in the Adam Walsh Act. Let's talk about two very important studies. These were meta-analysis, so they took a number of other studies on recidivism and looked at all of the results. Only 13% of sex offenders commit a new offense within 4 to 5 years following their release during this study period. The numbers get a lot higher in a 15 to 20-year follow-up period. But I do want to say that a number of these studies suggest two problems with the recidivism rate among sex offenders that we can't account for. The first is there have not been really good long-term follow-up studies of sex offenders. So 30, 40-year periods of time. With general criminal behavior, there are a lot of really good follow-up studies, but there haven't been with sex offenders yet, because we just really started researching sex offenders about 25 years ago. Really good, broad studies on sex offenders. The other problem is the failure to report rate. So few people, we looked at the statistics already, about 66% of all sex offenses go unreported. And so our recidivism rates that we have in these studies, it's as good as the data that we have. And so we don't really know how good these numbers are yet. But I feel really comfortable that we will know, hopefully in the next 10 or 15 years. So let's talk about where we are now. Well, we're stuck with the Adam Walsh Act. In the sense that the federal legislation requires the Adam Walsh Act. Legislatures have been very slow to recognize the research and the literature relating to sex offenders. I want to tell you a quick story. I'm just checking how much time I have left. I want to tell you a quick story. Many of you have heard of this case. There was a swimmer at Stanford who was convicted. The young man's name is Brock Turner. The only reason I know that is he's from Dayton, Ohio. And he got all the press in Dayton, Ohio. He came back to Dayton to live with his parents, and I quite frankly feel sorry for him in the sense that the media follows him around everywhere. He can't go anywhere. Other than that, I don't feel sorry for him. He was convicted of raping another Stanford student following a night of very heavy drinking by both of them. That does not in any way sanction his behavior. But for whatever reason, the sentencing judge in that case, the jury found him guilty of several offenses. The sentencing judge sentenced him to 6 months of local jail time. Now in Ohio, that offense would be a mandatory 11 years in prison, no early release. But in California, whatever discretion the judge had, he did 6 months of local jail time and then was permitted to return to his parents' home in Ohio. He appealed that conviction too, and I've read the decision of the appeal of his conviction. This kid's delusional if he thinks his behavior was not inappropriate. But that's not why I want to talk with you about it. The reason I want to talk with you about it is immediately after that judge sentenced Brock Turner, he was the subject of a recall vote. And he was recalled. In California, their recall process is the public can place on the ballot the removal of any elected official, and there are obviously criteria associated with that. Overwhelmingly, the judge was recalled, based solely on that case. And so therein we have one of the problems with changing the requirements of the Adam Walsh Act, because you have legislators, you have judges who so fear the reaction of the public, the continuation of that moral panic, so fear the public's reaction to anything that is deemed to be, and I'm going to say this in quotes, soft on sex offenders. And it used to be when I first started as a judge 17 years ago, the media was in the courtroom all the time. It didn't matter what the case was about. They had the resources to be present. Now, the only time they're present in the courtroom is if we have a sex offense involving a child or the murder of a child. Otherwise, they seem to be uninterested in the criminal justice process, which is okay with me because I don't want to be on the news. But it's concerning. Why is it that only those types of cases garner attention? And then what type of position does that put the judge in? Feeling like, boy, if I'm not tough enough on this person, I'm going to be in the same boat that judge in California was, where I am deemed not to be sufficiently harsh towards a sex offender. And that's the same attitude that the legislature seems to have. And I apologize to any of you who are present here who are members of the legislature, but it is a tough sell. How can we sell to the public when they are so influenced by the moral panic that the media continually regenerates? How can we justify changing legislation that will be evidence-based as opposed to emotionally based? Because the Adam Walsh Act, Megan's Law, the Jacob Wetterling Act are all emotion-based. Again, no research, no data supported any of those acts. There is no research that demonstrates that sex offender registries make children safer, make adults safer. There is no correlative research. And if you find some, I would love to hear about it, but there is none. No research has verified that placing an individual on a sex offender registration and requiring them to register, whether once a year, every 180 days, every 90 days, makes you or anyone else more safe. Instead, from a judicial perspective, it stigmatizes an individual. So that young man I told you about at the outset, he did not go to prison for having sex with his sister's 14-year-old friend. We placed him on probation, tried to get him some assistance in getting a job, but think about the consequences that you're all, I'm sure, aware of that relate the collateral consequences of being on a sex offender registry. His mom wouldn't let him live in her house anymore. He didn't have anywhere to live because mom's neighbors went online, saw all those pictures I showed you of my neighbors, all right? She said, you can't live in my house. I don't want this stigma attached to my home. Had a hard time finding a job because in Ohio on the sex offender registry, your place of employment is also listed. What employer wants to have some community member who may patronize their business go on a website and see, you employ registered sex offenders. And so he couldn't get a job. He didn't get his GED. We tried and tried, but he would not get his GED. Essentially, he is now a young man with no opportunities. No one will hire him, no friends, and now he's living on sort of the fringes of society where we know that criminal behavior often occurs. Because why? Because no resources, no family connections, etc. And so what happens? He forgets to register. No other crime. In Ohio, we have a completely unforgiving sex offender registration law. You miss one day. I don't care if you're in the hospital. I don't care if you broke your leg, if you're in a coma, whatever. You are late one day, you will be charged with failure to register. There is no grace period. The Adam Walsh Act does not contemplate a grace period for registration or notification, meaning updating your information. And so this young man forgot. He was living in a homeless shelter. The law in Ohio requires that the county sheriff, once you have failed to register, send you a notice. And if you register within a 7-day period, it's before your drop dead cutoff date, then you will not be charged. Well, if you're living in a homeless shelter, he didn't really have an address. And so he didn't get the notice, didn't register, convicted for the first time. First conviction in Ohio is not a requirement to go to a required prison sentence. The judge assigned to that case, put him on probation, same thing. Let's see if we can get him housing. Let's see if we can get him a job, some stability in his life, worked for a while, but now, he's now 22, and what happens between the time we're 18 and 22? Most of us are going to college. Most of us are developing our adult relationships. He did none of that. And so then he's off probation again. Now he's 24 and gets arrested for another offense. Because again, living in a homeless shelter doesn't, I don't know about you, and I'm going to tell you something about myself. I'm all over my kids. I mean, they're all adults, but I'll still remind them, did you do this? Did you do that? I'm not a helicopter parent, but sometimes, I don't know, it's the Catholic in me or whatever. Just got to remind them. He didn't have anybody reminding him of anything, nothing. And so he's got no resources, no support, no place to live, no job, and no impetus to go in and register. And now he's serving 3 years in prison because of our unforgiving, non-evidence-based law that suggests, it doesn't suggest, it says, you committed one failure to register. Well, if you did it again, you must be a really bad person. This young man has not committed any other criminal offense. And I apologize, I don't have the statistics with me, but I'd be happy to share them with you. The number one offense committed by registered sex offenders is failure to register. Sex offenders don't then become thieves. Well, I mean, obviously sometimes they do, but that is not the pattern. Most sex offenders, again, especially if it's a pornography offense or something, they typically are educated, have a job, etc. They're not like this young man, not everybody. So they're not going to commit other criminal offenses. But the number one offense is failure to register. So how do we mesh that with the assumption in the Adam Walsh Act that you got to be on that registry because we got to know where you are, because you are dangerous and you are going to commit some future offense. Again, no research suggests any correlation between the requirements in the Adam Walsh Act and the risk of reoffense. And so as a judge, I have advocated that we go back to a risk-based assessment. Chuck that $600,000 that we're losing from the Burn Justice Assistance grants. We're paying so much more to hunt down people who are not dangerous. And I will tell you that I absolutely believe I have looked them in the eye, and there are sex offenders who are so dangerous They should not be out in society. So I don't want you to think that I believe that every sex offender can be rehabilitated. Absolutely, I am not that naive, folks, all right? But I think I have seen the spectrum of sex offenders, from the 18-year-old having sex with the 14-year-old to a guy who adopted 3 kids so he could have sex with them and pimp them out. All right, I feel that I've seen the entire spectrum, and I do believe that there are plenty of very dangerous people who are sex offenders who we do need to watch out for. But the vast majority of people who commit sex offenses do not fall within that category. And we must reach, what other area of the law, well, I shouldn't say that because I think the law is often not evidence-based. What other area of life do we accept practices that are not evidence-based? Would you go to a doctor who said, you said, I got something on my arm, and if the guy said, you know what, I got this great new treatment, I'm gonna put grass on it, I'm just gonna try it, right? We're not gonna go back to that person. We want our doctors to be evidence-based, don't we? We want it to work. Why don't we want the law to be the same way? Why don't we demand that the law be the same way? That we have evidence-based practices in our laws. And quite frankly, we have been working on it. The dean talked earlier about an opioid task force, and I think really every state has one now, unfortunately. But with the opioid addiction, the opioid crisis, we have really worked hard on evidence-based practices. What treatment works? What treatment works for opioids? That might not be the same treatment that works for a cocaine addiction. It might not be the same treatment that works for alcohol addiction. We are working on evidence-based practices there. Why aren't we doing it with sex offenders? And so I'm not sure if I think my time is, I got about 10 minutes, but I'm happy to answer any questions that anyone has. And I will tell you one other thing I want to mention. When I first started doing research into this area, someone told me, and we're elected judges in Ohio, someone told me, you better be careful about what you say, because you're never going to get elected again. Because people will think that you are soft on sex offenders. And that's not an attitude that I want to take. I want to take an attitude that is, I should be doing something that is evidence-based for people that stand in front of me, and not imposing laws that are based on a moral panic. And so I encourage all of you to, to be brave and do what's right, because while this is not a group of folks that the public is sympathetic to, and again, as I said, I'm not particularly sympathetic to people who commit offenses against children and harm people. I certainly am not. But let's restore evidence-based practices. Let's find some evidence-based practices for sex offenders. Can I answer anybody's questions? Yes, ma'am.
We have microphones right here.
Sure.
You know what, Alex, I think, has the very first question.
I do?
Yes, you did.
Well,
I'm going to be on this side of the room.
I think you may have just answered it, but in Ohio, of course, you run for election and re-election, and I was just wondering if your advocacy ever became an issue in any of your campaigns.
Well, we talked about this last night, I think. Fortunately, where I live, if you win a contested election the first time, they typically will leave you alone. But I haven't had a contested election since I've become advocating on it. And you know what? If I do, that's the way it goes. I'm not going to change my attitude because somebody might say, you're being soft on a sex offender. I'm not willing to do it. I think there are a lot of elected officials who are willing to do that. And I'll be the first to tell you, I have a brother and a cousin who are both in the Ohio Senate. And I've talked with both of them about this, and the attitude of both of them is the same. This will never get passed. You're never going to pass anything. And if I can't convince the two of them, we're not going to be successful.
I have a question right here, Alex. Go ahead.
Hi, my name's Ty. I'm a prospective JD student. And just listening to you, it just sounds like the data suggests that the moral panic theory has led to an increased concern for criminal behavior in individuals required to register as a sex offender?
Both. So the moral panic, and if you read the literature, the moral panics throughout our history, the HIV, the AIDS epidemic, wasn't really an epidemic, was it? But the moral panic created this idea that we had this AIDS epidemic. We needed to be fearful of people. So that's an example of a moral panic throughout our history. There is, today is December the 7th, right? Pearl Harbor was bombed 77 years ago today. There was a moral panic immediately following the bombing of Pearl Harbor relating to Japanese citizens living on the West Coast. What happened? We put them in internment camps. Were any of them dangerous? Nobody that I know of, all right? But the moral panic started the concern about sex offenders, and it led to sex offender registration laws. And then those sex offender registration laws, it's that continual cycle of the moral panic. Well, they're a registered sex offender. I should be afraid of them, right? My sister-in-law, she regularly, and she's a lawyer, she regularly goes on the sex offender registration in the county they live in to see if there's any registered sex offenders that have moved into their neighborhood. And then she tells all her neighbors about it. Personally, I think that's ridiculous. It's not based in evidence. It could be the 18-year-old having sex with a 14-year-old. It could be child pornography that has an entirely different dynamic and different concerns about contact offenses, but it's a cyclical, it continues. We get worried about Jacob Wetterling being kidnapped. We don't know in 1989 that it was a sexually motivated offense, but we're going to create this storm, and then we have these laws. Oh, wait a minute, now we have registered sex offenders. We need to be really afraid of them. Now we can't change those laws. We need to be really worried about all these people. So I'm not sure if that answered your question, but it's a continual cycle of fear relating to the first concern was somebody committed a sex offense. Now we inflate it or conflate it to a point that is not based on evidence.
Right, you cited in your personal experience with the gentleman that had trouble registering, and so he increased his criminal behavior. That's what I was referring to.
Well, he didn't increase it, and he has not been convicted of any other crime. Yeah, his only crime was failure to register twice. Right, so no other sex offenses, and again, I can't off the top of my head give you the numbers. It's very low, but some of it's in the PowerPoint. The recidivism rate among sex offenders for new sex offenses is very, very low. Again, we don't have really good long-term studies, though. And obviously, we also have that low reporting rate. Somebody over here had.
Alex, do you have someone? Anybody over here have a question?
Good morning, Judge Huffman. Thank you so much. I enjoyed every minute of your talk. Just as a sort of a little support, I'm an advocate in the state of Connecticut, and what we've learned about if somebody is non-compliant because they didn't do a paper registration, it's simply predictive that they may forget again. That's all it can say.
Absolutely.
So what I wanted to talk about is that here in the state of Connecticut, we're somewhat unique, and we have 10 years of data from the Office of Policy and Management, and it's 2 5-year studies. And basically, both of them came out almost even Steven with sort of a 3.6 to 4% within 5 years reoffense rate or rearrest rate. And then it got down to about under 2% for remanded back to prison. So I was just curious. We were talking at the table about the recidivism rates among sex offenders. 13.4% committed a new sexual offense within a 4 to 5 year study. What was possibly lumped in there that might?
I think it's every sex offense. I'm happy to talk with you afterwards about where all of these statistics are from research studies. I did not compile any of these statistics or mash any statistics from any, a bunch of research together. These are verifiable statistics.
No, I understand.
Sure.
And another statistic we use in meta-analysis is the Department of Justice does these, and year after year, decade after decade, it's been about 5% before registry, after registry. But thank you so much.
But again, there is no data that tells us that there is a correlation between sex offender registration laws and public safety, or reduction. It's quite frankly, it's my sister-in-law is the poster child, all right? She is and please don't tell her this. She is the poster child. She has bought into the moral panic. Oh my gosh, she and my brother have 5 children. She is so fearful of what's going to happen that she can't be realistic. And I've said to her before, you should be more worried about what happens in our family, there's no registered sex offenders in our family. But you should be more worried about that than you are about the people that live down the street from you. And again, moral panic, she buys that conflated understanding of sex offenders as opposed to reading of any of the research.
Thank you again.
Jennifer, I'll catch you this way. Here you go.
Thank you. I enjoyed what you had to say, or most of it anyway. I
thank
would
you.
like to thank you. Got a really good laugh. You got a really good laugh there with "Please don't tell my sister-in-law." But I'm going to ask you: would you please tell your sister-in-law? Could you start with one person, and maybe we'll have that. She'll tell 2 friends, and she'll tell 2 friends, and then some change can actually be made.
We have actually discussed it, and again, it's the power of the moral panic. She buys that and not the research. And unfortunately, when we talked about the Adam Walsh Act, there was no invitation for professionals to come in and talk about the fairly small amount of research that had been done at that point in time. No invitation. It was only victims, again, senators, congressmen, who could, even my own, actually now our governor, who was our senator at the time, talking about cases in their state who, that was the impetus for this. And there was no research behind it.
Obviously, it's not good enough in the system, but it's also not good enough in your home and in your.
I agree. Oh, trust me, I've talked to her. I've picked my battles, and this one I wasn't going to win.
Good morning, Your Honor. I actually have 3 questions for you.
Yes.
The first is, if a 14-year-old girl signed a loan for a car at a car dealership, would you consider that a contract?
No, I would not.
So may I respectfully suggest to you, instead of calling this consensual sex, to call it non-forcible sex?
In Ohio, the term is consensual, and I apologize, but in Ohio, that is considered, our only statutory terms are consensual and non-consensual. And non-consensual is considered to be anyone who is intoxicated, under the influence of any substance, is disabled, and is under the age of 16. So I apologize if I used a term that was offensive, but that is the statutory term that I am used to, so I apologize.
Yeah, in the slide, it just refers to it as consensual sex, and I think it's really better described as not forcible. The second question I have for you is, if a 30-year-old male has sex with a 13-year-old female, do you consider that socially deviant or sexually deviant?
Boy, I'm going to defer to Robin, because in my layperson's opinion, it's both. That would be my opinion. But I think the experts are better qualified to discuss whether that's sexually deviant or socially deviant. It's certainly socially deviant. And sexually deviant, if you look back on the slide, it's my understanding that sexually offending, having a sexual relationship of any type with someone much younger or much older can be considered to be sexually deviant.
And my third question is, are you aware of the research based on offenders in federal prison for violating the laws with regard to commercial sexual exploitation of children, the research of their hands-on contact with children as well, after they've been convicted of the images?
I'm familiar with some of it, but that is not my area of expertise.
Okay. It's controversial, but it does challenge some of the slides that you have with regard to the notion that people who view those images are not having contact with children.
There is some research that demonstrates that individuals who view child pornography typically do not commit contact offenses. And I am aware of other research that indicates that some of those individuals do commit contact offenses. And so, as I mentioned, the research is really only about, we've got this period of time of about 25 years where we've had any, I'm going to use the term good research relating to sex offenders. But some of that, it's still being developed. And that's why, again, we go back to the Adam Walsh Act or the Jacob Wetterling Act or Megan's Law, and what research were those laws based upon? We absolutely have to protect children. We have to protect everyone who is vulnerable, but we must do it in an evidence-based manner. And while we're still learning what some of that evidence is, we do have a good body of evidence that can help us have evidence-based practices. I think.
Thank you, Judge.
Thank you.